Hello and welcome back to Insightsias. Today we shall discuss about the Draft Competition Commission Amendment Bill 2020. This bill seeks to rehaul or revisit the 18 years old Competition Commission Act of 2002. And this Competition Act of 2002 provided for the constitution of the Competition Commission of India. And before this, the Competition Act has been amended twice, that is, once in 2007 and the other time was in 2009. So today we shall discuss about the key provisions of the Draft Competition Amendment Bill 2020, its significance and what was the need for this bill. But before going further to understand the key provisions of this bill, let us understand why the Competition Act was needed and what was it for. See, here the main intention of this act was to establish a commission which is called as the Competition Commission of India. So the job of this commission was to promote and sustain competition in markets and to protect the interests of consumers and to ensure freedom of trade carried on by other participants in markets in India and for matters connected therewith or incidental thereto. So in simple terms, the task of this commission was to prevent practices which have adverse effect on competition in India. So like we mentioned earlier, this act was amended twice, once in 2007 and the other one was in 2009. This bill here proposes very significant changes, including imprisonment for non-compliance with directions of the Director General and commitment and settlement procedure in non-cartel cases, and very importantly, more expeditious combination review processes. But today, let us confine ourselves to those amendments which are relevant for our prelims as well as mains. But before going further, please note that these changes or amendments proposed in the bill are based on the recommendations made by the Competition Law Review Committee, which was constituted in the year 2018 and submitted its report in 2019. So the first change here is with respect to change in the regulatory structure of the Competition Commission of India. Firstly, to make the Competition Commission of India more robust and effective in dealing with new age issues, the Competition Commission Amendment Bill provides for the constitution of a governing body, and the composition of this governing body includes the chairperson of the Competition Commission of India, its 6 whole-time members, and the secretary of the Department of Economic Affairs, Ministry of Finance or his nominee. It will also have the secretary of the Ministry of Corporate Affairs and 4 other part-time members to be nominated by the central government. So what does the constitution of the governing body mean for the Competition Commission of India? See, so far the Competition Commission of India was vested with adjudicatory, advisory, investigative, quasi-legislative and advocacy functions. But now with the constitution of the governing body, CCI will now discharge only the adjudicatory functions. Here adjudication means the legal process by which the judge reviews evidence and argumentation, including legal reasoning set forth by opposing parties or litigants. So this is one significant impact of this bill on the Competition Commission of India and its functions. Next, as per the amendments proposed, the governing body will be vested with the power to make regulations, take measures to promote awareness and create a national competition policy. Now besides this, the governing body shall also exercise general superintendence, direction and management of the affairs of the Competition Commission of India. And more significantly, this bill seeks to create an obligation on the governing body to seek public comments on all regulations. So this statutory provision here means the governing body will have to mandatorily ask for public comments or reviews. So the major implication of this mandatory provision is that it brings in transparency and democratic rule making to the system. And further, the main function of the governing body will be non-adjudicatory and will include making CCI regulations, entering into MOUs, promoting competition advocacy and assisting in developing a national competition policy. And other changes brought about by this bill in terms of organization include that DG will be appointed by the Competition Commission of India and not the central government. But the main concern of merging the office of DG with the Competition Commission of India, though indirectly, is that it may be an attack on the functional autonomy of the Director General. Further, as per the bill, for adjudication, the chairperson will have the power to appoint panels of 3 whole-time members. So these are some of the significant changes with respect to the organizational changes. And changes here with respect to combinations include the reduction in statutory deadline to 150 calendar days. Earlier it was 210 days. So this means the cases with respect to these combinations have to be reviewed within 150 calendar days. But there may be an extension of 30 days in case of defective form filing or additional time sought by parties to respond to the CCI queries, that is the Competition Commission of India queries. And next, there shall be a statutory deadline of 1 year from the date of consummation of the combination to invalidate deemed approvals, including green channels. See, here some major importers have been given the green channel clearance. What is this? It basically means clearance of goods is done without routine examination of the goods. It means they have to make a declaration in the declaration form at the time of filing of the bill of entry. And the next important change is that DGs have been given powers to impose criminal sanctions. Based on these amendments, a person can now be imprisoned for up to 6 months and or can also be fined up to rupees 1 crore. Next, it also provides for introduction of settlement and commitment procedure. So this means parties under investigation for abuse of dominance or entering into an anti-competitive non-horizontal agreement will now have the option to settle the case with the Competition Commission of India. So lastly, we can say that this bill is a positive step in the right direction of an efficient Competition Commission of India version 2.0. Now one can hope that the consultation process leads to beneficial outcomes and most concerns raised by the stakeholders are appropriately addressed.